My name is Hania Miller. I'll go ahead and get us started. I'm in-house counsel at the Home Depot and a board member at large for the Georgia Bar Association Construction Section. And today's presentation, titled Anatomy of a Construction Project and Key Players, provides an in-depth overview of the construction project lifecycle and the principal participants who influence its success. And our presenter today is Jake Carroll, who is a partner at Nelson Mullins. Jake advises clients in the construction, manufacturing, and real estate industries. He is also a published author, an authority on Georgia construction law as co-author of the Georgia Construction Law Handbook, a leading treatise published annually that many of us on this call have sitting on our desks or in our offices. And so without further ado, I would like to hand it over to Jake. Welcome, Jake.
Good afternoon, everybody. And thank you for that introduction. Going to go ahead and start so we get a full hour of knowledge in. Um, so today's session is part of Construction Law 101. It is a series jointly sponsored by the Atlanta Bar and the State Bar Construction Law sections. We're covering a variety of topics. And the topic that I was assigned is the anatomy of a construction project and its key players. Essentially, how the moving parts of a project fit together and where lawyers fit in. My goal today is that each of you, if you're a new attorney, leave with a working map of the players, phases, and risk relationships that drive every construction matter. And if you're a veteran construction attorney, I hope you learn at least just one new little facet or something to think about as you're going through your day. Short little agenda. Here's a quick roadmap of what we'll cover. Brief introduction and background of myself. The idea of a project life cycle, concept through closeout, common delivery methods and how they shift risk, key project characters and their responsibilities, and then how risk, money, and disputes move through the system. By the end, you should have a clear sense of where your client sits in this structure and what risks are live at each phase. Just a little bit about myself, a graduate of the University of Georgia and Mercer Law School, federal clerk for Judge Weigel in the Middle District of Georgia. Following my clerkship, I entered private practice with Freeman, Mathis, and Gary, where I represented contractors, architects, engineers, and subs under my mentor, Bart Gary. I moved over to Nelson Mullins in 2020 and continued my construction practice as well as the construction practice with our group in Orlando. I've represented clients on some notable projects that you might have heard of, the Hyundai Meta Plant in Savannah, SK Battery Facility in Commerce, and multiple commercial developments in Atlanta across from a lot of you. I'm past chair of the Atlanta Bar Construction Section, and that section is near and dear to my heart. I think I've served in every role. As mentioned, I'm also co-author of the Georgia Construction Law Handbook. And I tell you all that to say that I pretty much represented everyone we'll discuss here today in some form or fashion. So I've got at least a little bit of knowledge that I hope I can pass on to you all. So before we talk about the players, which is originally what I thought I signed up for, I realized that it helps to kind of orient around a typical project timeline. And in my mind, at least, every project moves through 6 basic phases, from concept through to design, procurement, construction, closeout, and then the black box of post-completion. And each phase brings different documents, different decisions, and different risks that attorneys have to think about when they're when they're advising clients. So for attorneys, the first step is always to identify where are we in this timeline. That tells you what's already happened and then what's still yet to happen. We're going to go through each of these quickly. In the concept phase, the owner or developer is really kind of testing feasibility of a project. The kind of project participants you're going to see in the concept phase, obviously the owner, the developer, maybe a lender, land use council, environmental consultants, all those people are involved in kind of deciding, can we bring this project to life? The activities you would go through site selection and do due diligence. You may look at entitlements, you may look at permits, zoning, all of those factors kind of come into, can we build this project? At this phase, your typical documents or agreements, you're going to see memorandums of understanding, term sheets for the purchase of real estate, non-disclosure agreements, development agreements. You may see your geotech, some kind of early environmental reports. And this, in my mind, from a construction perspective, is the period of the project that we are least involved in, for better or worse. The typical attorneys that look at this phase are your real estate, land use, environmental, sometimes lending. True construction counsel, we get kind of called in as a after effect, but it's an important phase to remember. After concept, you move into the design phase, and this has to happen generally after the site is selected and the owner decides exactly what they want or a concept of what they want to build, and then hires a design team. In this phase, your typical contracts or documents you're going to be looking at are architect and engineer agreements, sub-consultant agreements occasionally, permitting documents, sometimes draft construction contracts depending on the delivery method. But since there's no construction yet, this phase is really all about defining the scope of the project, budget, constructability. And for us attorneys, the biggest value we can bring here is, number one, clarifying the standard of care that our designers are going to be held to. We're going to be looking at scopes of basic design services versus additional services, and ensuring that some of these initial documents align before procurement starts. Now, moving on to the procurement phase, this phase kind of transitions from design, stands in between design and then execution into the construction phase. Its focus is on bidding and contracting, so you would have invitations to bid, bid protests, contract negotiations, and subcontractor selection. You are going to see some construction contract forms, subcontract forms, certificates of insurance, bonds, bid packages. And really, this is where I think construction counsel, our involvement, at least in pre-construction, kind of spikes. This is where we finalize scope, we can advise on price, and you really start to look at risk allocation in the contracts. Moving on to construction, for lawyers, this is the heart of the practice. It's advising through claims, documentation, trying to avoid disputes. It's where all the players converge: owner, architect, contractor, subs, consultants, inspectors, lenders. And this is really where the rules that you put in place for procurement and your contract documents come into play and are realized. Some other key documents you're going to see in this phase, pay applications are a big deal, change orders, requests for information, daily reports, hopefully they're made and maintained. Insurance is a big deal. It also carries the most, I think, active risk. You might have differing site conditions, delays, potential defects, payment disputes, liens, weather, force majeure. All of those events are going to have an impact not only on the delivery of the project, but your next two phases, final two phases. And so that leads us to closeout. Projects that survive construction reach closeout. You're going to have here substantial completion, and that key document, the certificate of substantial completion, which milestone that says this project or the portion of the project is ready to be used for its intended purpose. It is also the milestone that typically triggers retainage, if that's what you negotiated in your construction contract, warranty periods. The certificate of substantial completion also precipitates typically a punch list that you have to complete for final completion. And this is where, again, attorneys are very busy. We get liens, we get final payments. You start talking about the release of retainage. What are you going to hold back? And really, it's an exciting phase for most of the project participants. Yeah. Then the final phase, and I kind of added this because typically you only have those first five, but for attorneys, this black box post completion is also bread and butter. Issues shift to warranty enforcement. And insurance coverage is going to be disputed. You've got the statute of repose. And so for the next 8 years after substantial completion, you've got the potential for claims to be brought at 8 years with a couple exceptions. And then you've got dispute resolution. This is where if you had a bad project, you're going to have delay claims, you're going to resolve construction defects. All of that is kind of wrapped up in this post-completion life cycle. Now, after I thought about this, I said, well, you've got what we need to talk about, what phase of the project goes through. Then I was excited because we were going to talk about our key participants. Even before that, though, I realized that the number and even the presence of some participants kind of depends on how the project is delivered. So now that we know when things happen, we have to look at kind of how the project is structured. And the delivery method is what I'm calling, and I think what most people would call it, defines the relationships of the construction contract or the project parties. So who holds the risk, who communicates with whom, and what contracts exist. Now going through each of these is beyond the scope of, I think, my presentation, but I will just go through them briefly. In the design, build, bid, build, I think this is the traditional model. And still the one we see most frequently on projects. The owner holds separate contracts with the architect and the general contractor, serving as the central hub of communication. That differs from design build, in which the owner enters into a single contract with one entity, the design builder, who both designs and builds the project. In this case, it can be faster. I think that's at least what a design builder would tell you. It shifts the design liability to the contractor side. But it theoretically would simplify communication as well, as it's just the owner talking to one person instead of the owner talking to both the designer and the builder. I listed two others: construction manager at risk versus construction manager as agent. Both of these are used or ideal for more complex projects where design and build, both of those factors need to be considered together, and that considering them together early on, collaborating can really reduce impediments to completion later on. The construction manager as agent, the difference there is with at risk, the construction manager is at risk. They are typically for a guaranteed maximum price on the hook for delivering a project on time and on budget. Compare that to construction manager as agent, and the construction manager does not hold the risk for completion. Instead, the owner typically holds the contracts, and the construction manager is really just running the project, but without cost or performance risk. This is less common, I think, in private practice than the first three that we see, but it is common in projects that require kind of significant owner control. So might be mission critical facilities, municipal work. Yeah. Finally, I put integrated project delivery. I think this is very rare, but I have had one case or one project that employed this method. And it's where both the owner, architect, and contractor kind of come into a multi-party agreement to design, execute, run a very complex project. Typically, it's in kind of a first of kind hospital or lab, tech campus, where really everybody has to be on the same page the whole time. Now I go through that, and there are many other delivery methods and contract structures that we could talk about. I think these are the bigger ones. But the reason I'm going through those is to talk about why it matters. And in any case, when an attorney gets brought in at whatever phase, you need to think, first of all, who's in contract with whom and who's responsible. So for design errors, that's going to change whether or not you have a design bid build where the architect's responsible for the design versus design builder where the design builder is responsible for the design. Same thing for coordination issues, delay. A lot of this also goes to who's holding the insurance, what lines of insurance are they holding, what kind of dispute resolution is in play between all the participants, and who can assert or defend claims. Okay, so with that kind of background, now we can talk about key participants. So looked at project structure. Let's look at the people who make it work or occasionally make it fall apart. The owner right here is set in the kind of middle. And so this is what we would see in a typical design bid build scenario where the owner has separate contracts with the contractor and the architect. Owner, and I got this, by the way, from our Insurance and Bonds 101 presentation earlier this month. Because I thought it did a good job of at least setting out, look at how many people are involved already. And this is a fairly simple project. The design team, I may refer to eventually, is this kind of architect and then down, civil engineer, structural, all these kind of sub-consultants. Together, they make up the design team. The owner right here setting the vision ultimately bears the risk for the project. And then you've got the contractor with subcontractors and suppliers. And then they also mentioned in the insurance and bonds a little bit about the design build subcontractors. So I was looking at that and then I said, well, there's a few more roles that I want to talk about in this project. So I added a few. And a big, some big participants that I just wanted to quickly mention. So I've mentioned the developer. They are going to be an entity that, again, makes the owner's vision kind of come true. You may have a tenant. The owner may be a commercial landlord. They may lease either part or all of the premises out. And during construction, the tenant may actually have some say-so in what's being built, particularly if it's if it's being built specifically for a tenant, they already know what they want. Tenant's going to be involved. I put the owner's rep in here as well because, like we talked about, the construction manager, the owner's rep can have a significant role in project management, scheduling. It could be their job. Lender, I could not omit this very important party to construction. We have, it's been a long time since I've seen a self-funded project. At some point, a lender is going to be involved to provide construction financing, and they've got some things they want to say and some protections that they need. I also had to mention the government because they are also a huge role. They play a huge role in not only the zoning of the project and the permitting of the project, but typically also issuing certificates that let you use the project. They require inspections. That's just in the construction phase. They might also play a role in the financing phase. If, for example, the government's offered some kind of tax abatement or tax-free bonds, government's going to be involved. And then we've already learned about this month, insurance carriers, huge role in construction. You cannot have construction without insurance. And then I also put sureties in here, and we'll talk about those, but I did put them in the same box just because when I started splitting them up, they looked a little too crowded. So they're all kind of shaping what's going on in the project. So then after I listed those, I thought, well, maybe I could show like who is contracting with who and for what. And so I started adding just a few little arrows. And just to kind of add like what we started talking about or what I was thinking about. So the tenant may enter into a contract directly with the contractor to build out their space. Makes sense. The developer might enter into a contract with just the site contractor to get the site ready for a pad before it sells it to the owner. The owner may decide to enter into a contract with a supplier directly because they want a certain kind of countertop that only the supplier makes, and they think they can get a better price than the contractor. The lender may enter into a contract with their own consultants to inspect the project during construction. The developer may also enter into their own agreement with the civil engineer, for example, to design the project. The contractor may enter into an contract with the architect as part of a design build project. These are just some of the options that could happen. Then I thought, well, that's a very limited example. I really need to show like what else happens. So then I thought, well, let's look at what insurance carriers and sureties, their obligations. And it creates this complex web that you can see that outlines all of these potential contracts obligating people at the end of the day to deliver a successful project. Each of these have different interests, different obligations. And it's a little overwhelming. So what all of this taught me was that number one, we weren't going to cover everything that I needed to talk about in an hour. And but number two, what I could do is slow down and walk through each of these participants, some typical contracts that govern their relationships and what risks they might have on a project. So I came up with this kind of bigger list of 7 general groups of project participants. And we're going to talk about each of these in more detail. But when you break it down like that, it doesn't seem that overwhelming in my mind. So going back to the owner, as you saw from that web, the owner is the hub of the project. Every other contract eventually traces back to the project owner. They define the scope, they control the money, they pick the delivery method. They're going to be parties to the owner-architect or contractor agreements. They're going to be parties to loan agreements, to leases with the tenant, development agreements with developers, consultant contracts with their own consultants, geotechs, possibly civil engineers. All of those agreements are going to define whose job is what and who bears the risk for what. The key risks that I typically think about when I represent owner, number one, scope, who's responsible for what. Insurance coverage is next. Always check who's holding builder's risk. Make sure that everybody's on the same page about who's holding builder's risk, and make sure the contract matches and says owners holding builder's risk or contractors holding builder's risk. After that, and you've got some what I call kind of sub risks, still very important, but not something we see as much. Decision delays. If you've got an indecisive owner, that's going to have an impact on completion. If you delegate too much authority to another consultant, you can end up being bound by a decision that you may not be happy about as an owner. If the other thing, if there is some kind of huge unforeseen condition and the owner doesn't have a financial contingency or the resources to make up that gap, that is a significant risk that the owner needs to kind of contemplate in all of its agreements. Our job as counsel is to help owners manage these risks even before design begins, and translate and protect those risks and protections against those risks into contract documents. The next set of, or next group, kind of with the owner are owners' representatives, consultants, construction managers. They're not on every project. They play a small role, but I just wanted to mention them. And mention kind of their risks. And it's just right there, scope creep, making sure that everybody's on the same page as whose job is what, how much agency of the owner do they have, what's their responsibility, what's the standard of care, and then also thinking about a conflict of interest, potential conflict of interest if they're responsible for selection or bidding or scheduling, making sure that those interests are aligned to one side or the other. Around the owner, and this was at the top of our little map, I put lenders, developers, and tenants, because not everybody deals with these participants, but they are there frequently. Lenders, obviously the golden rule, he who has the gold makes the rules. So the lender's going to control the project purse strings. They're going to be funding through periodic draws. They're going to be inspecting progress. They're going to be relying on those certified pay apps in making disbursements under a construction loan. Typically, the kind of agreements you're going to see a lender, construction loan agreement, obviously, promissory note, assignment of contracts, rents, and frequently you're going to see them ask for a completion guarantee, not only from the owner, they may also ask it from the general contractor. They are also more and more, well, for a long time now, I've been asking for subordination agreements from subcontractors and contractors that basically subordinate the lien rights of those who are performing work on the project to that of the lender, particularly if construction has started before the lender gets involved. The next participant, the developer, again, not every project has them, but if they do, you're going to see a development agreement that's going to have typically scheduling obligations and delivery obligations. They may also be parties to purchase and sale agreement, construction management agreement. Really just kind of depends on the role that the developer is playing in the project. Then finally, tenant. Again, not every project has one, but a tenant, I say end user or occupant, they may fund tenant improvements. Tenant improvements are an important part of the project, not only in construction to finance completion of maybe an interior or fit up of a building. They also have significant implications on lien rights. In Georgia, if a contractor is doing work for a tenant and wants to assert a lien, generally speaking, that contractor would only have a lien right on the leasehold interest unless the owner has consented to the work. And typically, the best evidence of that is through a tenant improvement allowance. So something to think about when you're looking at different project participants and roles. Now to the architect or engineer. So their main job is to take what the owner wants and puts it into some kind of drawn or a set of instructions that the contractor can follow and build. Ultimately, that's the architect's job. In reality, they kind of sit in a dual role. Where they're not only designing the project, but frequently they're also the limited agent of the owner in administering the project. Particularly the AIA forms kind of put the architect in the center of approving pay apps, maybe initially resolving disputes, uh, generally making sure that uh, the whatever the contractor has done is conforms to the design documents. And that's a big responsibility. They're responsible for creating, coordinating, code compliant documents, then reviewing submittals, they review pay apps, change orders during construction. And really the tricky part is that they're also supposed to be this neutral interpreter when disputes arise, which means that sometimes they irritate both the contractor and the owner. And that role becomes even more complicated when you think about those two different delivery methods. In the first method, design, bid, build, the owner ultimately is obligated to the owner, and the architect is ultimately obligated to the owner, and they're getting paid by the owner. So question becomes, well, are they really neutral, or are they favoring the owner, or what is their kind of role? Can we even trust their judgment? Going to the next delivery method, that design build, now the architect sits in privity with the contractor. And so those same questions, but on the contractor side, start coming up. Well, if the contractor is ultimately responsible for paying the architect, does that impact their kind of neutral decision making? And there's a conflict there that's just it's something to consider when you're considering delivery methods. From a risk standpoint, architects, number one is going to be professional liability. Number one, what's their standard of care? What's their coverage for errors, omissions? And what's their liability? Because they can have a huge exposure if liability is not limited in their agreement. Another thing that's important for architects and risk consideration is scope management. A lot of times I'll see where an architect has signed an agreement, the architect owner have executed an agreement where the owner understands that the architect is supposed to be doing contract administration, but the architect has excluded that from their services or presented it as an add-on. That can lead to increased cost, confusion. So it's better that everybody get on the same page about that early on. The other thing that the architect has to think about is their coordination. They are responsible for coordinating all of the sub-consultants that we're about to talk about, and kind of marrying all of those drawings together into what's hopefully a beautiful compendium of as-built drawings. That can be complicated if the owner hires some of these sub-consultants themselves. If the architect doesn't really have responsibility for the sub-consultants, or somebody else is responsible, that can really make their job a lot more difficult. Speaking of some of those sub-consultants, and I'm not going to go through each of these in detail, but just to kind of get you familiar with some of the people that you're going to hear about. Civil engineer, responsible for the best way I've heard it described is that the civil engineer is responsible for designing how people interact with the building. And then they design sidewalks. They do a lot more than that, but it's a good idea. They're important for site grading. They decide maybe drainage utility plans. They're coordinating with the government for tie-ins, stormwater management. Yeah, they're pretty important. The next subconsultant you may see, structural engineer. They're responsible for designing the framework, the actual frame, and then also those foundation systems, your footings, slabs, those sorts of things. MEP you'll hear, or mechanical, electrical, and plumbing. They design your building systems like HVAC, power, lighting, plumbing, fire protection. The important thing to think about too in Georgia is that each of these is a type of professional engineer. So when you have a mechanical engineer, structural, civil, they're going to have their little stamp issued by the Secretary of State, and it certifies to the public that whatever they've drawn, whatever they've designed, is safe for the general public. That also imports some liability to them. And again, we'll focus on that in more detail in another 101 series, but just kind of a precursor. Couple other categories of subconsultants. Geotech, which I'm sure everybody will have or has had at least one case that deals with some kind of soil issue. Your geotech is going to be right in the middle of that, providing reports as to the soil composition and makeup of a project. You've got the land surveyor, who's important for establishing legal boundaries. They're the ones who draft your legal descriptions typically. They're the ones who come up with plats. They're very important. Two others we don't see as much, but environmental engineers, testing. They're going to conduct your environmental assessments, phase 1 and phase 2. You might hear in a development or real estate project. If you're doing work on the coasts, they're going to be talking about wetlands, where you can work, where you can't, how to mitigate any kind of wetland impact. They may also test materials during construction. And then commissioning agents you'll typically see on larger projects. Generally, they're just supposed to verify that building systems perform as intended. You'll often see commissioning in like large-scale manufacturing facilities where they're kind of testing systems before they go into full-blown running. Now, contractor executes the work, carries the general performance risk. They control the means, methods, sequencing, site safety. In my opinion, the core of their liability or exposure is in documentation. Getting those daily reports, writing impacts down, because most contracts say if change isn't memorialized in writing, didn't happen. Some other risk considerations, missed notices. If the contract says you got to report weather within 5 days and you didn't, that's going to be an issue. Incomplete daily reports. All of those are kind of important risk considerations for contractors. Subcontractors. They work under the prime contractor, and they are going to be doing your kind of specialized work. You might have you are going to have an electrical sub, HVAC sub, concrete sub, you might have an elevator sub. They do special limited scopes of work. Their challenges, in my experience, are payment timing, scope definition, and flow down risk. Most subcontract disputes involve either paid if paid or paid when paid clause, release of retainage, or overlapping scopes of work. In Georgia, I think another big risk consideration are your lien rights. Remembering that in Georgia and most states, lien rights are in derogation of common law. You've got very strict notice provisions, very strict recording provisions, and any kind of misstep, and you lose a lot of those rights. For attorneys, our job is just often to help clients preserve rights long enough to negotiate a solution, particularly on those payment disputes. For suppliers, they're one step further down the chain. I know on our first slide, I had them underneath contractors. In reality, they should be under subcontractors. One of my favorite things about if I represent a supplier is that their contracts might be governed by the Uniform Commercial Code. So there's a fun interplay between Article 2 and construction law that kind of brings you back to your kind of base law school training. And it's just a fun group to represent. Some other things that you need to think about when representing suppliers is what kind of agreement are you under? Typically, it's under a purchase order or supply agreement. And you're going to, and I'm going to bring out another term, battle of the forms. You could have kind of two conflicting terms and conditions that govern the materials that are provided. Deciding which one of those governs, it's a fun task as well. So making sure that your contract kind of specifies those delivery terms, escalation pricing, pass-through warranties. Those are important things to think about when representing suppliers. Everybody's favorite, insurance. So they form the insurance and then suretyship, and they're two separate, though related roles. They form the financial safety net for the project. Insurance carriers can price and quantify risk. They expect losses. Sureties instead kind of guarantee performance. And so that's who you're going to go to in each kind of risk issue. So for insurers, your disputes are about coverage, notice, and exclusions. For sureties, it's all about whether a default was declared properly, whether an obligee was overpaid, underpaid. They're also in two different titles. So in Georgia, Title 10 is where you find provisions about suretyship, Title 33 for insurance. And they are separate obligations under Georgia law. The final group that I want to just briefly cover are governing bodies and jurisdictions. They're building departments, they're fire marshals, they're the Georgia EPD, Georgia DOT, EPA. They decide kind of when work can begin, when inspections happen, when a project can open. OSHA, how the work is performed. They can really also dictate the project schedule more than anything. If there's a delay in permitting or conflicting agency requirements, that can really kind of impede progress of a project. Another risk to think about are jurisdictional overlaps. Whether or not you have a city code uh, that might not be in harmony with the Georgia EPD regulations, which ones control, and then you add a overlay of federal regulations on there, and you kind of see there's a whole web of regulatory compliance that matters. So always check which jurisdictions govern, and then talk to your contractor, you can get a permitting consultant, but they have more interaction than attorneys most of the time with these governing bodies and jurisdictions and can kind of help you navigate those. So going over the participants, I'm going to move into kind of financial controls that you see on kind of every construction project typically. Number one, you've got a draw process, this idea of kind of interim payments being made by pay application. Could be tied to a lender, may not be, but it's just a typical concept. Retainage, it's another issue, typically released at substantial completion, but could be withheld till final completion, depending on who negotiated the contract. Another kind of choke point here, if retainage is subject to lender approval, that can kind of hold up release of final payment. So as an attorney, I always tell my associates to make sure the payment procedures and performance provisions align with what we're supposed to deliver and also what the financing documents call for. The next thing I just wanted to briefly talk about risk allocation. I think this is where lawyers, our work is most visible. You're going to be looking at indemnity provisions. You're going to be looking at insurance, like we talked about, who holds builder's risk, who's an additional insured, whether or not there's a wrap-up policy with either owner-controlled or contractor-controlled insurance programs. But all of this can kind of be set out in my mind, like a risk ledger where you shift some risk to one party, some risk to the other. And it's really the owner just trying to assign responsibility all the way down. So these are important things to think about. Again, limitation of liability too, and the ever popular waiver of consequential damages. Next thing, just briefly, talking about conflict. When conflict becomes inevitable, the process is very important. AIA forms, I've set out their kind of typical procedure there: notice, initial decision maker, mediation, arbitration. I've seen more claims lost on missed notice deadlines, particularly in litigation, than on the merits. It's important to remember those. And then I do just want to make a point about mediation, that it's not just procedural. I think construction is unique in that early mediations really can be an opportunity to resolve disputes early on. You can learn about the positions of both sides, and in an open and honest mediation, I think you can resolve it to the best interest of all parties. So that's my just little plug for ADR there. And then Finally, project closeout. It can feel administrative, but it really is. It's important and it triggers a lot of deadlines. Substantial completion, particularly if you use the AIAG 704, triggers warranty, triggers retainage release, triggers lien deadlines. Punch list is important for achieving final completion. This is where all of your lien waivers need to come in, all your final lien waivers, and protecting both the owner and lender from double payment. Warranty claims, that's when this starts, the 1-year correction period, which is typical under the AIA. Your other systems are going to have a longer warranty period, typically roof 20 years. So triggering those warranties, it's important for the owner. This is also where you're supposed to get all of your final documents and as-built, operation manuals. All those final documents are what the owner and future parties are going to be relying on to know what was actually built, what was done, and what their remedies are. And then speaking of remedies, it also triggers statute of repose in Georgia, which is 8 years from substantial completion with some exceptions for personal liability, personal injury. So anyways, right under an hour. And that is everything that I've got. I hope you all enjoy the presentation. If you have any questions, feel free to reach out to me. Otherwise, I hope you all have a great rest of your week and a great Monday.